AAA versus BBB. GR number 212448, January 11, 2018. This is for criminal procedure, specifically on who may file crimes that cannot be prosecuted de officio. Subtopic: persons who must prosecute criminal actions. Question: who is the real party in interest and who can represent the people before the Supreme Court? Answer: in criminal cases, the people is the real party in interest, and only the Office of the Solicitor General can represent the people in the criminal proceedings before the court. And the private offended party is but a witness in the prosecution of offenses whose interest is limited only to the aspect of civil liability. Facts: this case was about the applicability of Republic Act number 9262, where the alleged marital infidelity was committed abroad, specifically in Singapore. Petitioner AAA, the offended wife, filed a complaint against respondent BBB, the respondent husband, before the city prosecutor of Pasig. AAA claimed varied forms of abuses, one of which was the alleged cohabitation of BBB with a Singaporean woman. The investigating prosecutor found sufficient basis to charge BBB with causing AAA mental and emotional anguish through his alleged marital infidelity. However, when BBB filed a motion to quash, the same was granted by the Regional Trial Court of Pasig despite the existence of probable cause on the ground of lack of jurisdiction since the alleged illicit affair was conducted in Singapore. The Regional Trial Court, in its ruling, admitted that Republic Act number 9262 presents ambiguities, but held that the quashal of the information must still be ordered following the underlying fundamental principle that all doubts must be resolved in favor of BBB. The prosecution filed a motion for reconsideration, which was likewise denied. With an intention to further appeal the case, AAA filed a motion for extension of time before the Supreme Court while waiting for the response from the Office of the Solicitor General on her request for representation. However, the Office of the Solicitor General was unresponsive to AAA's plea for assistance. Hence, AAA filed the petition in her own name before the lapse of the extension given to her by the Supreme Court. Thus, AAA sought direct recourse to the Supreme Court via petition on a pure question of law. BBB opposed the petition and argued, among others, that only the civil aspect of a criminal case may be appealed by the private offended party and that the petition should be dismissed outright for having been brought before the Supreme Court by AAA instead of the Office of the Solicitor General as counsel for the people in appellate proceedings. Issue: whether the Supreme Court should entertain the petition for having been brought by AAA instead of the Office of the Solicitor General. Ruling: yes. The Supreme Court should entertain the petition for having been brought by AAA instead of the Office of the Solicitor General. Under the existing jurisprudence, the Supreme Court entertained a Rule 45 petition which raised only a question of law filed by the private offended party in the absence of the Office of the Solicitor General's participation. The Supreme Court said that there were instances that they permitted an offended party to file an appeal without the intervention of the OSG. One such instance is when the interest of substantial justice so requires. In this case, the court found that under the circumstances, the ends of substantial justice will be better served by entertaining the petition if only to resolve the question of law lodged before it. The issue for resolution concerns the correct application of law and jurisprudence on whether or not Philippine courts are deprived of territorial jurisdiction over a criminal charge of psychological abuse under Republic Act No. 9262 when committed through marital infidelity and the alleged illicit relationship took place outside the Philippines. The novelty of the issue was even recognized by the regional trial court when it opined that there is still as yet no jurisprudence on this score, prompting it to quash the information. It is thus necessary to clarify how Republic Act No. 9262 should be applied in a question of territorial jurisdiction over a case of psychological abuse brought against the husband when such is allegedly caused by marital infidelity carried on abroad. Therefore, the Supreme Court should entertain the petition for having been brought by petitioner AAA instead of the Office of the Solicitor General. In applying the foregoing, the petition was granted, the resolutions of the regional trial court were set aside, and the information was reinstated.